Hello, everyone. Today we're talking with Alexandria Cohen, a paralegal at Harrison Law, and we're talking about estate planning. She practices and is talking about Arizona, but honestly, I think it's quite universal advice. So I hope it helps a lot of people. If you can introduce yourself more, Alexandria,
Hi, I'm
please.
Alexandria. I'm the estate planning paralegal with Harrison Law. Hopefully, soon to be an attorney. I will be finishing law school here in May. So I'm looking forward to that. So hopefully, I'll be coming back eventually as an attorney.
Oh, that's amazing. And I kind of alluded to this, but I always like to kick off the podcast by asking, like, who would benefit from listening to this podcast?
Honestly, anybody, any family members, young adults aging from the age of 18 upwards, family members that people don't even think about that they would need this. And a lot of times, older adults, as they're getting into retirement, they start to think about this, and it's really for anyone. You don't have to have $1 million to have an estate plan. It's pretty much protecting just you.
Yeah, protecting yourself and I guess anyone that would that I don't want to say would benefit from
Well, yeah.
receive or need what you have to give. It's all
Hmm.
very awkward of a conversation, but an important one.
Yeah.
That's why people bring in paralegals and lawyers to this,
Hmm.
because otherwise it's better to bring them in the beginning, not at the end. Uh,
Yes.
People are upset and angry. So, what is the bare minimum that someone needs in this
I would
estate
s-
planning situation?
I would say at bare minimum, have a will and
Okay.
powers of attorney. Powers of attorney are probably one of the best things for an emergency situation. If you're in an accident and someone needs to sign off on surgeries, who doctors can speak to. Use an example with myself, my husband. This was as we're in the process of getting these documents done. Right after we got married, he cracked his head open and they didn't talk to me for like 3 hours. And I
But
was like, I'm his wife.
but you
I
were
just,
married, so that didn't
uh-huh.
even help?
Mm-mm. And I was shocked, but I had to fill out paperwork. They have forms there that give you permission, but it took 3 hours for me to even. And usually in that kind of emergency situation, you're not wanting to fill out paperwork.
Yeah. So in that situation, if you had that paperwork already filled out, that's something you could like fill out, pull up on your phone or something, or
Yeah, Arizona actually has it's the Arizona Healthcare Directives database where you can upload your powers of attorney, living will, all of your documents that they would need a HIPAA waiver, and it's like a QR code, and it just pulls up all of your documents. So if you're going even in for routine surgery, I always say we email all of our clients scans of the PDFs once they're created, once they come in to sign. That way you have it on your phone. And then that card also works with emergency personnel. So it does work with paramedics throughout the US.
oh wow, that's very
Mhm.
interesting. And I'm sure there's something like that in hopefully in most states, if not.
Mhm.
And then just to ask, because we're in kind of a less certain time, uh, especially for like queer couples where they may feel lack of recognition or something like that. So does it have to be an official marriage or something, or even if it is an official marriage or not, can you get this by getting this paperwork in order? Does it give you more rights?
Yeah, like I said, it's beneficial to everyone. You could have a separate estate plan and then a joint one if you have commingled assets. We
Mhm.
can do for if you have a domestic partnership agreement or stuff to that, we can change the language in there. It's completely flexible to be able to help and
Yeah,
everyone.
because there are people in positions that maybe don't have the same relationship with their parents that wouldn't want their parents making those decisions. They'd want
Hmm.
a different
And
level.
that's
So you want
a
that writing.
perfect situation. We have the young adult safety plan, so you don't have to own a home. You don't have to have a significant amount of assets, but maybe you don't want your parents to be able to sign off, and you want one of your best friends who you see all the time and know that will be there and your parents live somewhere else, it's probably the best. You don't want them to take over something that you probably wouldn't be okay with in that time to make the decision.
And that's not a term I've heard of before. A young adult safety plan. What does that mean?
That's what we recommend for any kids that are just turning 18, preparing to go to college, or if they're planning on taking a year off abroad, who would be making those payments on a credit card or making sure things are continuing to flow as life goes on, or if you can put a power of attorney in effect without being incapacitated, so that if you're traveling abroad and need to make sure these things are continuing to be made on your behalf, you can have a family member or a friend have that power. And then once you come back, it's signed over to your power again.
Oh, wow. Okay. That's great. And I guess especially for younger people, uh,
Mm-hmm.
young adults,
Mm-hmm.
but probably all of us because of life admin and all, you kind of
Mm-hmm.
need someone to remind you of that when you come
Mm-hmm.
back or something because you don't necessarily want that to be there forever as some that
Yeah.
be the person forever.
Yeah. And you don't think about it if you're going off to school and something happens, they don't call your parents right away. It's, you know, you're just kind of sitting there in limbo until someone's able to give that information. A lot of schools, a lot of times it could put pressure on schools, like if they're allowed to release that information, it's just best to have it, even for young adults.
Okay, wow. Yeah, absolutely. And especially people in a vulnerable situation.
Mhm,
You and when you can't maybe speak for yourself.
mhm.
In a situation like this, how does it differ when we're talking about state to state? How I assume Arizona has some differences from other jurisdictions. Do you want to elucidate some of that?
Yeah, yeah, Arizona. So it differs from state to state. So for Arizona, the federal threshold of where what would trigger probate is 200,000 qualifying assets. So it used to be 75,000, which was pretty low. So really anybody at that point, we would have to create a trust. So that's where we kind of see if you need a trust or not. So a lot of times, for example, young adults, if they don't own a property at this time or they don't have a significant amount of assets at this time, they would just need a will. It wouldn't trigger probate for Arizona.
What
But
does probate
having
mean?
probate is the court system that comes into play when someone passes if they didn't have a trust or any of these documents assigned. So it's a trust and a will and an estate plan is being able to identify all of your assets and who it goes to, who you would like to receive it, who can manage your accounts. And it's just a protection of you rather than having the court system. You're paying attorney's fees, you're paying court fees, and it's just money's going back to them rather than your family.
Okay. And
So
then
Arizona specific is the $200,000. So typically here in Arizona, at least from what my experience of seeing everything, it's more so if you own a home, it's you definitely need a trust.
okay.
If you own a business, how does your business incorporate with your trust? Do you have an operating agreement that discusses what happens when someone dies? Does it go to a spouse? Does it go to your trust? Can it go to your trust? There's a lot of different things that have.
Partners.
Mhm,
Yeah, we've definitely have for those that are interested in the podcast, we talk quite at length at we talk there's some divorce law in there and all, but there's a lot of business divorce discussion as well
mhm,
because kind of like a marriage, you don't always prepare for the worst case scenario, and
mhm,
there are a lot of them with businesses, or God forbid if someone passed, or if you just don't get along anymore, things like that.
mhm.
Absolutely. That is, so how does it work then if you establish something in Arizona, but you live in another state? Are you establishing like, is it dependent on where you live, on where your business is located? What if you move states? Are people updating these things? Do they have to update these things? Or is it if you've established in one state, you under their laws, it's applicable in another state?
So it's wherever you have your primary residency. So let's say I have my trust here in Arizona and I decided to move to California. You never change your actual physical trust, you'll just do what's called a restated trust amendment. So it's a document that gets placed right on top of your original trust, putting it into that state's laws, literally just moving it all over. So it would be filed where, depending on the state, some states you have to file it, Arizona doesn't. They took away that a long time ago, but it's just meant to be private with your documents, but you're meant to update them every 3 to 5 years just to make sure no one's moved. It's meant to change as your life changes. So you don't want to make sure everything's up to date, your addresses, phone numbers, who's in charge. We've had scenarios where family doesn't get along and they don't talk to one child anymore. Something happens, and do you want them to receive half of your estate? And just
Hmm.
changes like that can come.
Or as simple as you change your phone number, and if it's power of attorney, you
Yep.
just didn't realize, and that's actually a deep, it's probably very hard, hopefully,
Yeah.
to find
Yeah.
that person's phone number to contact again. That's why
Hmm.
I guess hospitals are better at constantly asking you, do you need to update your information? Maybe
Hmm.
we need to have that habit across legal documents as well.
Hmm. Yes, and I always on my family members, everybody, make sure you're checking it. It make it a routine because even with a primary care physician, if you go in just for a routine or just to even get, for example, my eyes checked, they asked if I had a power of attorney. It's like, oh, I didn't even.
Oh,
I'm like, oh, okay, I do. Here you go. So it's easy, just as easy as that, being able to hand that over. But it also brings into your thought, oh, wait, everything's up to date, right? Just to make sure.
absolutely. Yeah. I for as a 42-year-old in London have never been asked this question in my life. I guess it's a little different because everything is through the NHS. Like there's a centralization of not really of information, but no, no one's ever asked that. No, I don't have any of these things. Um, what are powers of attorney then? So people understand what that means and how they can differ from having a trust.
A lot of times people call in if something's happened to someone or they've passed away, they think that the powers of attorney are still in effect and they're not. So your trust will name someone who is in charge of your entire estate. That is called your successor trustee. Now, your powers of attorney, there's a healthcare and financial power of attorney. These do not have to be the same people as the ones managing your trust. So it only comes into effect when you're either incapacitated or you sign over that power. And it's only while you're living. So once you've passed away, it's in void at that point. It has no meaning to any of your assets at that time. Powers of attorney for financial allows the people to make the ones you name in that situation make payments on your behalf, continue to pay a mortgage, or if they needed to give money to something, make payments on
Healthcare.
bills to be
Hmm.
able to keep the ball rolling so you don't go into a negative space for that. With healthcare powers of attorney, it's being able to sign off on surgeries, making sure you're making the right accommodations for them. If for whatever reason something happens to the one you've named, we always, always, always say you have a backup listed. So if so and so isn't available or they can't get in contact, then who else do we call? So we always say at least list a backup person as well.
Okay. And in the situation when someone has died and it's a trustee, I
Mm-hmm,
think
success.
is that typically the person that is like the main recipient, maybe a spouse or an adult child, or is that a conflict of interest for them to be managing the trust if they're receiving it? I don't know.
No, not at all. It's whoever, we always say it, whoever is, you know your family better than we do, you know your friends. It's whoever you think would be the best one with very good management skills. Uh, so being able to go into banks, closing out accounts, listing and selling what needs to be sold. A lot of times we see it's the older child that's being named. You can
Yeah.
also name people to work together as co-agents, so equal authority. It's based on how you know your family. For example, I have my uncle on there, very well, I guess, managed well. I think that would be the best person to have and play fair. There's it doesn't really affect of how any distribution goes. They do have the ability to say final say on stuff. So if there's fighting issues, it's no final say. This is what will go.
Oh, so someone you really trust.
Mhm.
And then we've talked a lot about finance, but just because we live in this digital world now, does that person automatically, I don't know, in Arizona, are there laws about access to your digital assets? Like, this is really, I have an uncle who passed like 5 or 6 years ago, but
Mhm.
he has an active Facebook account that people comment on and things
Mhm.
like that. These are assets in the world that maybe you don't want posthumously. Can you give that person access to passwords, access to like enact just like what would happen, what you would like to happen with your remains, what would happen
Mhm.
to like digital footprint and I mean, not just shutting down bank accounts, but shutting down like your social media accounts and things and email.
Yeah. There's with those kinds of things, those never really get discussed with your actual estate plan. But a lot of times where things that we can't write in there, we always say, okay, well, make sure you have at least a list of where you keep your documents and then at least have a list of passwords, where all of your bank accounts are, combinations to safes. At least let that person know who you have in that authority, where all of this is. And then you can leave notes if you would like, saying, please do this with this. But you can't, for example, with receiving something, you can't say you have to go to college to receive your inheritance. You can't dictate past that. So they're a beneficiary or they're not. So you can't really, it's up to the person who's managing the estate. So if you want to write something nice, say, please close out my Instagram account, it's really up to
Okay.
the person to do it, but they're not legally obligated.
Okay. Yeah. So what you just described though makes most rom-com books a lie. Like he has to get married before 35 to inherit the business is
Oh,
just
yeah, I know.
as myth. Okay, I'm shook. I thought those were so fact-based.
No.
So we've touched on like the financial threshold for a trust, but
Mhm.
a will is just you don't have to have a trustee of the will then, or are there other differences we need to know when considering a trust versus a will?
Yeah. So kind of like it really boils down to where your assets are of what you need. So if you, like I said, that threshold of 200,000, if you're under that, you just need a will and you'll name an executor who would be managing your smaller assets. So bank accounts still, items such as, for example, a ring, who you would like to have someone receive. It makes them obligated to give the item to somebody. So
Mhm.
you would list that out in your will. This is also where you would identify guardianship for any minor child. So obviously, typically it's the spouse or the biological parent, unless they've revoked their parental rights, then you would name someone to be the guardian. So what would happen to your kids? That's a lot of what we hear. If something, you could be going on date night and you and your spouse are unfortunately in an accident, and then now what happens to your children? It takes away that stress of family members who can take care of the kid, and it takes away the stress of having to go through the court system to be able to, you're writing it out saying this is who I want to take care of my child.
Okay. Yeah, that is the piece that we need to most and we do at least want to think about. That's
Mhm.
why my partner and my husband and I don't fly separately from our child. That is probably not the most reasonable way to deal with a legal issue, but these are
Mhm.
awkward.
Mhm.
How,
Like
yeah.
if you think about it, like you love your parents, but would you want them taking care of your kid and parenting your kid? You don't know. Like it's where you can really, or my crazy aunt, I don't want taking over for my child or
Yeah.
my sister. I'd rather have someone I know who's responsible and who would at least somewhat raise them as I would.
Mhm. How does it work on the other hand with debt? if someone is the power of attorney or the recipient, what if they don't know that someone had all this debt or something? There's 20, the average American has more than 20,000 in education and student loans and another 20,000 on average in credit card debt. Is that like you can give someone something terrible too?
Yeah, you wouldn't be taking that on. You can't be, you're not going to inherit debt from somebody. The estate would then pay out based on those assets. So if you were in probate, that's where unfortunately a lot of information gets public and a lot of creditors or scams can come into play trying to get money from an estate. The second they see someone's past, or if even with, I've seen this with bankruptcy, if you've gone into foreclosure, that information's all public record and you get phone calls from people trying to say, oh, they owe me this amount of money. Well, it becomes a headache at that point. So it's up to the trustee to be able to pay off what needs to be paid off. For example, even a mortgage, typically it's list and sell the property and then you take the excess proceeds to put it into the big pool of assets. So it'll be managed through the estate, but it's up to that person that you sign to be able to do all of that. So it's very, like I said, naming the person who you think can manage
Personality type.
everything.
And I guess, do you need to get permission from that person to give them this responsibility or no?
We say that you should at least let them know, because you don't want to have the situation where, like I said, you name one person and then you don't have a backup. Now you're in probate
And
to
what
get
is
letters.
probate exactly, if you want to define that a bit better?
Yeah, probate is the court system that happens when someone passes where they don't have any of these documents. So
Okay.
this could even come in contested probate, probate with a will. So if they only had a will and didn't get a trust and they own a property and they're past that threshold that triggers probate. So
Okay.
now people are having to go through court. Informal probate is where there's not too much assets, and it's being able to just file it with the court to get letters of authority to make sure you're able to talk to banks, gather everything that needs to be gathered. Formal probate is if you have nothing or there's a lot of hands in the pie, and a lot of
Or
people
debt,
coming out
I
of the
assume.
woodwork. Mhm.
Debt
And it's,
again, I see as
yeah.
like real reality for a lot of people
And
who,
then it's just, again, money going out
mhm.
of your, than what could have been done to protect it. So it all kind of falls back with money. And
Mm.
and that's where you see a lot of greed too, with family members. It's sad, but death brings out the good, the bad, and the ugly.
Absolutely, yeah. And how does funding your trust work? How does this process continue?
Yeah,
What do people
we
need to do?
yeah. We highly recommend working with a financial advisor for funding your trust. So there's a supporting document called the Certification of Trust. I don't know particularly if it's different in each state, but what we have is the certification. It's a summary of your trust. Your trust is going to be about 30 pages long. The certification of trust is about 5. And this will also list out who's in authority, and banks will typically ask for that to make sure you have a trust and then who they can speak to once yourself, even if it's just a singular trust or a family joint trust, who they can speak to. So listing out the trust as a user on an account or a beneficiary, because it's in benefit to your beneficiaries. So
Mhm.
it to go through the trust rather than being caught in limbo with probate. So you would have to go, for example, a basic checking account, having the beneficiary on as the trust, because it's still going to whoever you want it to go to. It's just going
Mhm.
through the trust instead.
Okay, okay.
And
And
then with properties, you do what's called a beneficiary deed if you have a mortgage still in the property. Typically, mortgage lenders have fine print saying you can't change the ownership of the property while
oh,
you have the mortgage unless you get written permission. So if sometimes people want to go that route, that's totally fine. Otherwise, we do a beneficiary deed, also known as a transfer at death deed. So we record it on the property. It still shows your name as you own it. It's just once you've passed and your death certificate gets filed, the ownership then transfers to the trust, avoiding probate. If you
Okay.
have,
And then
yeah,
that mortgage then transfers the person that is responsible for that mortgage, which is,
no, so it transfers to the trust. It'll allow the trustee to be able to do what they need to do to either if they want to pay it out and keep it for themselves with if they're one of the beneficiaries and they say, actually, I want to keep this house, they can take their proceeds if it calculates right. But
mm,
or they can list and sell the property if they would like.
okay. Wow, there's a lot. And all this stuff, like these feel like things that because most properties are over 200,000 nowadays,
Yeah,
unfortunately. Sorry to those young adults listening, and if you weren't aware. Um, is this something that is a requirement of getting a mortgage? Because you would think like they'd want these ducks in a row.
it I think it should be. It's not a requirement. I've seen, there's people who are afraid or think they don't need it because they don't understand what it means. So we just bought our first home. Immediately, I said, no, we got to get it in the name of our trust. So that's what we did. Once you have a trust established, let's say you move houses and you want to buy a new house at that time at title, just let them know you want to have the ownership, the name of the trust, because you're still the trust. You are the document. So it's just the matter of the name.
Wow, there's so much. And
But
then one topic we haven't talked on yet is another important one, but another uncomfortable one, but this living will end of life plans.
yeah,
Wow.
your living will essentially takes away the stress of the person as the power of attorney saying pull the plug. So this is a document that you're able to convey in writing that you're not able to convey about verbally, saying this is how long I would like to be kept artificially alive. Nowadays, you can be kept on as long as you want to be, but this is where you can say, I only want to be here for 7 days. And this is if all of the exhausted scenarios have been gone through, multiple opinions, then this comes into play. This
Mhm.
isn't a DNR, but it's saying if there's no chance of at the end of a terminal disease, you would just like to be comfortable. For example, I've put 5 days for myself. I would like to have family come in if they want to. And then if not, then we're good. At 5 days, that's where you take off. So it takes away that kind of stress that I think gets put on a lot of people in those situations.
And again, potential debt in the
Mhm.
United States, which is something to acknowledge, but all very fun questions you get to
Yeah,
ask, but very important ones. So hopefully
yeah.
people grieving don't have to be asking these questions because
Mhm.
most people don't want to do life admin anyway. But in a situation like this,
I,
especially. Mhm.
I think of it as you're leaving your legacy on, and you see so many different family dynamics, and it would break my heart if I saw a family member that doesn't even hear from their children ever, and it's like, well, why do you deserve to have their stuff, or why are you fighting over it? You never spoke to them. It's really kind of being able to, nope, this is set in stone. This is what I want, and being able to protect it for whomever. You can even donate it to a charity if you would like. We've
Which
seen
need
that
it.
too.
Yeah, which is fair enough.
Mhm.
And then because it is our global and we are talking a lot about cross-border or cross-state, is it typically that people with larger trusts, as the trusts get larger, they may have things on different states, or maybe they have a Delaware company, but they are based in Arizona, things like that. Is this where lawyers from different jurisdictions come together and work on this? Is this something that still can be done by a single entity or a single lawyer? How does that work?
It's based where you have your residency, so you could have another LLC or a business in a different state, you would just have the member of the LLC be the trust, the name of the trust. So it doesn't matter where it's at. I know, for example, California, I believe, does a transfer at death deed. Same thing as a beneficiary deed. If your primary residence is here in Arizona, but you own a beach house, you would do the same type of thing. Just make sure that there's a deed recorded on the property saying it goes to the name of your trust, but it's all in one spot. For example, if you're a snowbird here in Arizona, we have those a lot. You have 6 months here and 6 months there, but it's wherever you file your primary residency. So you can still own a home in Missouri or something, and as long as it's funded properly to the trust, then you're good to go.
Okay, absolutely. It is complex, it sounds like.
Yes,
So I can
very.
understand why you'd want your job is not sterile, but you are a bit separate from the circumstances.
Mm-hmm,
And that helps provide the perspective, the making sure all your ducks are in a row
mm-hmm.
and everything in an important way. So thank you so very much. And hopefully soon you'll be helping people and bring that experience as an attorney as well.
I look
In
forward to
yeah,
it. Hopefully, very soon.
yes, definitely very soon. Touch wood. What is the best way for people to get in touch with you?
Calling into our firm or sending at least an inquiry email, we would then just send an automated email saying, yeah, we assist with this. Just give us a call during business hours. And then it's usually myself giving them a call back just to go over our process. We usually send over a questionnaire to get at least all of your basic information. I always say fill it out to the best of your ability. Then we have a consultation with them to go over everything. And a lot of times, sometimes they'll list out themselves as their power of attorney. And I'm like, that would be cool, but who can we list? Who do you it's easier when you're able to explain it in person. It's
Mm.
just filling out information.
What do you say to people that are probably using like Chat GPT or something to try to do this themselves?
Don't do it. It's not an attorney. It pulls stuff from the internet, random stuff. I would not. I say, think of it like this. If you were on trial for murder, would you want a computer representing you?
Would you want your lawyer potentially hallucinating? Yeah.
Yeah, like no, I don't think so. I especially when it comes to your stuff, I think I wouldn't want something I just read off the internet to give me information. We had someone come in here saying they used AI to write their wills, and they're here in Arizona, but it was using Oregon's laws. It's like, huh? And they're like, oh, I didn't even know because you don't know.
And then that can't be a legal document, or it could be a legal document where they get screwed because they use the wrong state's laws or something.
It had it wasn't even a law on there. It was like random legal jargon written, and I tried to even look it up, and this isn't even a statute. I don't know where, how. So they're like, oh, so I mean, when you sign something, it's binding, but it's not. It's in void at that point because it didn't have anything really written that made sense. So it was
No.
odd. They're like, oh, I didn't know that. So I wouldn't trust even ones that are, you can download powers of attorney online. They're just not as good as having one up to date with everything current, and you don't know what you don't know, if that makes sense. You don't want to have contradicting statements of what you want, and then you have a random law written in there that's saying what you're asking for is not allowed.
Mhm.
Stuff like that.
Which these random services may also be using ChatGPT, et cetera, to write
Mm-hmm.
them. But there's also the other side of the security of putting that personal information in
Yes,
there. Could
it's
put you at
public.
deep risk as identity theft, could put you on a scraping list for like what you said, those fake debt collector scams that
Mm-hmm.
you could be actually opting in to your relatives getting screwed. So
Yep.
absolutely. And then just I keep thinking about this. where do people keep this stuff? Because if something, again, touch wood, were to happen, where are people keeping printouts in their house? Are they keeping it filed with an attorney and then there's like a notification to contact your attorney if things happen to get this information? Where are people keeping things? Like you said, you registered it with your eye doctor or something, part of it, things
Yeah,
like
that those are just the powers of attorney with that, but with your actual trust, certification of trust, in your whole big packet you get, we we tell everyone keep it in your safe or safety deposit box. In there, just allow the person who you know is your successor trustee know at least the combination to that where you keep it
that.
just somewhere safe. We've had, unfortunately, someone who had their house catch fire and all of their documents went. So we had to revoke their trust and then start from scratch. But it's just you try to protect it at least where you can keep it safe. You guys get the originals when you come in to sign, and we keep a copy of it, like the digital PDFs, just in case if you don't have it at this time, can you email me the PDFs of this?
And is
So
that
we
valid? Are those documents valid, the electronic versions? If,
Mhm.
again, God forbid, a fire happens
Yeah.
or coup?
Yes. The only time it would not be they want originals is when someone does pass. They want like a physical original document as well as a death certificate. Wouldn't be a copy of one. You would need an actual certified one. So Arizona requires wet signatures. So it has to be signed with blue pen by a notary. So you can't just do digital signing on.
Mhm. Wow.
Just a lot of
Of
scams are out there as well. So
course, yeah. Well, thank you so
yeah,
much. And thank you to our listeners. I'm sure there are people you know or myself that need this advice and that you need to forward this on to. So please do share it with them. And to the lawyers that inevitably are listening to this, I think this is a useful one to share as well. So please share it. And thank you so much. And
yeah.
good luck with everything to everyone. Thank
Thank
you.
you.